it's not so much that the court has taken these, what I would define as kind of radical steps rightward. Sometimes the court moves leftward, sometimes it moves rightward. But what I think is different about this court is that they were placed on the court with the express purpose of taking these rightward steps, and they've unabashedly done so.
Welcome to Pod Talks. Pod Talks is a project of protecting our democracy. We bring together the best minds in New Jersey and beyond to talk about some of the biggest challenges facing our democracy, our institutions, and our personal freedoms. I'm Sean Spiller, Chair of Protecting Our Democracy. Today, we have the good fortune of being honored, joined by the Senior Supervising Attorney and Director for the Supreme Court Advocacy at the ACLU-NJ, Alex Shalom, to talk about recent decisions by the U.S. Supreme Court and the impact that those decisions have on our democracy. Alex, thank you so much for joining us today, and I'm looking forward to what I know will be a great discussion with you.
Thanks, Sean. Looking forward to it as well.
And for our listeners, let me share a little bit about Alex. He's the Senior Supervising Attorney and Director of the Supreme Court Advocacy at the ACLU-NJ, where his litigation focuses on issues that disproportionately impact people of color, such as police practices, the youth justice system, and conditions in prisons and jails. While at the ACLU-NJ, Alex has appeared more than 90 times before the New Jersey Supreme Court on cases focusing on issues including pretrial justice, right to counsel, sentencing, search and seizure, and public access to police records. Alex also engages in policy advocacy in each of those areas, meeting with policymakers, testifying before legislative and rulemaking bodies, and appearing in the media. Before joining the ACLU-NJ, Alex worked as an assistant deputy public defender in Essex County. Prior to that, he served as as capital cases clerk for the Honorable Deborah J. Ports, Chief Justice for New Jersey Supreme Court. In 2017, the New Jersey Law Journal named him Attorney of the Year, and he's a fellow at the American Academy of Appellate Lawyers. Alex is a JD from NYU, his BA, summa cum laude, from Tufts. By the way, Tufts was one of my top choices for schools. I didn't end up going, but I thought a lot about it. And I have to also point out with a good deal of pride that Alex is a graduate of Montclair High School. So Alex, again, welcome and thank you for joining us.
Go Mounties. Happy to be here.
Excellent. Listen, before we get to some of it's where to begin, right? I mean, there's just so much going on. We want to talk about the Supreme Court. I think it's something that everybody is talking about, right? When you turn on the news nowadays, that's about all you can hear because it's one decision after the next, whether it's, overturning longstanding law, revisiting issues that we thought were settled, decades ago, to writing new laws, some saying, legislating from the bench, et cetera. There's just a lot to talk about, and I think everyone is for good reason. Specifically, I guess it's probably helpful for me and maybe those listening too, to kind of take it a step back though. And from your perspective, maybe hear what you think the role of the court should be. And is it functioning in that space appropriately now? And certainly as we talk about the court under Chief Justice Roberts, is it functioning in the way the court has traditionally functioned, or do you think it's kind of taken a turn and doing something that maybe is a little bit unprecedented?
Oh, I think there's no... So let me actually just, before I pontificate, let me tell you that there are a lot of people who think a lot more about the United States Supreme Court than I do. As you noted in my biography, I practice mostly in the state Supreme Court. And so obviously what happens in Washington has a deep impact on me as a lawyer, as well as me as a person and a father and a concerned American. But there are certainly court watchers who look at this court a lot more closely than I do. But I think even someone with my kind of novice view of the Supreme Court can't help but recognize that this court is far different than the court has ever been. And by design, I mean, we had presidents and we had presidents of the Senate, majority leaders of the Senate saying they wanted to create a Supreme Court that was different. For decades, we had a Supreme Court that interpreted the laws, found laws to be unconstitutional, and generally protected the rights of those without political power. And so I don't think the Miranda decision, which has been enshrined in our memories from Law and Order episodes and things like that, was particularly popular because the rights of the criminally accused, those subjected to custodial interrogation, aren't that popular. They don't play well in the voting booth, but they protect all of us. They protect innocent people from giving wrongful confessions, right? And so it's an important right that our court had carved out. protecting the right for people to control their bodily autonomy, for people to have birth control and access to reproductive health care. Those are important rights that our court has carved out. And sometimes it's politically popular, sometimes it's not. But what you can't say of courts of earlier generations is that they were placed on the court in order to do something. They were placed on the court with a political agenda. And here we had a president who made clear he had a litmus test. He wanted members of the court who were going to, among other things, reverse Roe v. Wade. So he fished that wish. We had the court do that last term. But I think the conservative legal agenda went far beyond overturning Roe. It also included getting rid of the consideration of race in college admissions. That happened this term. And then a broader item on their agenda is to empower business. And in order to do that, they want to take power away from the regulatory state. So from agencies that create regulations and things like that, the administrative state, this has been a bugaboo of the political right for decades now. And the court is poised to consider a case next term that will consider that very question. And so it's not so much that the court has taken these, what I would define as kind of radical steps rightward. Sometimes the court moves leftward, sometimes it moves rightward. But what I think is different about this court is that they were placed on the court with the express purpose of taking these rightward steps, and they've unabashedly done so.
Well, I mean, I think adding to that, right, when you see that, one of the appointments by our previous president, 2 presidents ago now, President Obama, was held. I mean, literally, you see that it was a very intentional process. So certainly no argument there. One of the cases that you mentioned, right, and I know it's right in your wheelhouse when I read for our listeners, your work on cases that disproportionately impact communities of color. You mentioned in your last statement there, the example of affirmative action in admissions, right? Students for fair admissions versus the president and fellows of Harvard College. That was a pretty monumental decision there, right? Ending affirmative action. We saw that there was strong dissent there. Justice Sotomayor, offered a pretty strong opinion there. But how do you see, despite the fact, as you note, that you work, we live in New Jersey, we work off of our state Supreme Court in many ways, but these issues do impact us nationally, and certainly when my kids are old enough to go to college, if they're going, and certainly others who have kids, it's going to have an impact. What do you see as I guess what can be done by colleges now to make sure that they remain diverse when they can't use race as a consideration?
So I've got at least 2 answers there, and there's obviously people who have thought a lot more about this than I have. But the first thing is that the opinion, horrific as it is, and flawed in its reasoning as it is, actually did not say that the use of race is totally prohibited in college admission. What it said was essentially checking a box and consideration being given for that checkbox is prohibited. And again, I think it's a silly decision that is logically flawed in lots of ways and will be very harmful. But the court was explicit in saying colleges could still provide applicants the opportunity to describe how race had impacted their life, either as a point of pride, a point of overcoming obstacles, those sorts of things in a narrative form, in an essay question, are still permissible. And so I expect you'll see lots of essay questions that offer candidates the opportunity to expound on that, and that will make the admissions process clunkier. And I think there are lots of ways in which it asks things that are hard to quantify, asks candidates to produce things that are hard to quantify. But that still is one possibility. The other thing is we know that affirmative action, race-based affirmative action, it was a step some colleges took to try to mitigate the both past discrimination and current discrimination. But they didn't do everything they could to clean their books beforehand. So, for example, you have huge preferences given to the children of alumni, the children of rich donors. Those preferences track in the other direction. They make a whiter student body. And so a good start would be following the lead of some universities. I think MIT is one of them, who've said, we're not going to give any advantage to the children of alumni. And to say we're not going to give advantage to the children who happen to have rich parents or rich uncles who can donate a library or whatever the case may be, that would make for more equitable admissions. And the other thing that the Supreme Court didn't rule out was class-based affirmative action. And certainly that is part of the diversity of campuses that we should all seek. I mean, the thing about this decision that was so stunning is, there are a lot of things, but in the early 70s, when the court was grappling with affirmative action, the court came to the conclusion that has been accepted now for almost 50 years, that diversity in higher education is a compelling state interest. The state, there they were looking at the regents of the University of California at Davis, but any government, any state university or private school who wants to have a diverse student body because it helps everyone. It helps white kids, it helps black kids, it helps Asian kids, it helps Latino kids. It's useful to learn from people who've had different life experiences than you. And so the court rejected that, this most recent term, saying that because it was unquantifiable, it couldn't be a compelling state interest. I think that's a very suspect legal conclusion when you think about the other things that we found to be compelling, right? We found, take the integrity of the courts has been found to be compelling. That's hard to quantify. National security, hard to quantify, but nonetheless compelling. But putting that aside, there are still other ways that states and state schools and private schools can reach that compelling state interest. I think race-based affirmative action is among the best of them, but they can at least use a variety of other tools to try and achieve the same result.
Well, I think you very clearly identified three of them, and I'd certainly heard some conversation around some of the socioeconomic considerations, et cetera, to make sure that diversity remains, and some other pieces. And certainly you highlight the fact that in some of the writings and other pieces, essays, there's an opportunity. So good point to note there. When we look at some of the other decisions that we see, it's some of them you shake your head at, and maybe some of them are just direct attacks that some would perceive as direct attacks, I guess. But when we talk about college affordability, let's go there. We're talking about college here. Maybe stick with it. 6-3 ruling we saw there, where basically Biden's attempt to wipe out the student loans of many for their college debt was overturned. What are your thoughts on that in terms of just the merits of that case specifically, and I guess positioning the need for congressional authorization?
So I think with that case and with other cases, they're bad on their facts and they're worse on the law. And so I believed that the president had the authority under the statute he was using to waive educational debt. I mean, the statute literally gave him the opportunity to suspend or waive the debt. Well, that's what he did. He waived it. And then the court said, well, did waive, what do they mean by waive? Could they have possibly meant this? Well, they said waive, and he waived it. So that's problematic. And I was gratified to see that the president is using other tools at his disposal to provide debt relief. But I think the case is actually far more troubling beyond just debt relief, because what it said is basically it created or helped, it amplified this newly created doctrine that the Roberts Court has created called the major questions doctrine. And basically what it says is sometimes there's something that's such a big deal. Last term, it was an EPA rule. This time, student debt. Such a big deal that we're not going to let Congress beat around the bush. If they want to do something, they have to explicitly say that. And so, I mean, take the student debt question here. What Congress did is it said sometimes emergencies are going to happen. And when those emergencies happen, we want to authorize the president to do a bunch of different things to student debt because we understand how crippling it could be. COVID was undoubtedly an emergency, and the president used his authority under that statute. And what the court said is no, Congress needs to be more specific. They need to say for this emergency, but that doesn't really allow Congress to plan for things in the future. And I think this is one of those gambits where the court knows the dysfunction of Congress, knows, and some of that dysfunction is systemic, right? Given the filibuster, given the need to given the undemocratic nature of the Senate, the idea that 60 votes would be forthcoming to cancel student loan debt, they understand is hard to achieve. And it's also true for other things. So it seems to be a court that is content with political branches that simply can't govern. And that is, I think, ultimately one of the, just going back to the earlier question, that's exactly what the conservative legal establishment, the right-wing legal establishment has wanted, which is the ability to have courts neuter the political branches.
So I guess, I mean, how much does that worry you? When you noted at the start, right, there were affected, they say everything's local, right? We all get that. And certainly as you go up from there and you talk about New Jersey Supreme Court, very impactful. But of course, as we're even some of the cases we're describing, they all have an impact on us in some way. How worried are you when you've got a very, let's call it an extremist minority kind of driving the direction that the court went in, intentional, as you've highlighted a few times here. We're seeing that in the decisions. You've highlighted some from Dobbs last year, right, to some of the ones we're seeing now reshaping what our democracy looks like. Are you optimistic, or do you think we've got to bring in some kind of reforms here? There's a lot of people talking about reforms to the court, whether that's be adding more people to the court, creating, you noted it before, the integrity of the court. Maybe I say with a little bit of a smile there, right? But that's coming under a lot of question with what some of the Supreme Court justices are doing in terms of gifts that they're taking and things of that nature. What's a solution? What's a path forward with a court like this and the decisions that are coming down and the impacts that it's having? What are options that are available?
So, Sean, I think you've talked about some of the major court reform proposals that are out there. I think they're all worthy of consideration. I think those people who are worried about disturbing norms at the court, I think that ship has sailed. I think those norms have long since been shaken. But I actually want to evade your question a little bit. Well, let me answer it directly and then evade it. So I'm very worried. I think we have, unless there is major court reform for which there does not appear to be political appetite, I think we are looking at several decades of terms like this. And a lot of political commentators have looked at this term and said, oh, this was terrible for individual rights. This was terrible for liberty. It was terrible for democracy. But it could have been a lot worse. So they're celebrating because of the near misses. And the truth is, there were a series of cases that went in favor of liberty, in favor of democracy, in favor of fairness, but they shouldn't have even come close, right? I mean, so whether we're talking about independent state legislatures theory, this really crackpot theory that would absolutely hamper those people fighting for democracy, that got 3 votes. So yes, the good guys prevailed 6-3, but that means, 2 votes in the other direction. And you're looking at the end of litigating cases in state court on elections issues. So I'm very worried, but I find some hope, and I find it in our state Supreme Court, and more particularly, I find it in William Brennan. So William Brennan, former New Jersey Supreme Court Associate Justice and former United States Supreme Court Associate Justice, in the 70s and 80s was starting to see a disturbing rightward trend in the U.S. Supreme Court. They were no longer protecting individual rights in the way that Justice Brennan thought they should. So he gave some speeches and wrote some articles where he suggested this idea of a new federalism, where state Supreme Courts could provide an independent basis to protect individual rights. And he was a Supreme Court justice, so the idea caught on in legal circles, and nowhere did it catch on more than in New Jersey. So the New Jersey Supreme Court started saying, look, we understand that the US Supreme Court will set a floor on the rights that must be provided to individuals, but they don't set the ceiling. And so under our state constitution, we can provide additional rights to people than those that are provided by the United States Supreme Court and under the United States Constitution. And we have now a rich jurisprudence for several decades of the state Supreme Court going further than the United States Supreme Court to protect individual rights. And I think that's the future, at least the immediate future, given the perilous state that the federal judiciary is in. And so I think I am that much more heartened by seeing members of the New Jersey Supreme Court understand their role, that their role is to protect the rights of New Jerseyans, and they have to do what they think is right based on the New Jersey Constitution, not based on what the United States Supreme Court decides. And so I think we need to see that in other states, but we need to continue to build the jurisprudence in New Jersey. And so that's what gives me my hope. That's what gives me my optimism, is knowing this ability of state Supreme Courts to say, we don't care what's happening. Obviously, we have to care what's happening in Washington, but we're not going to be bound exclusively by what happens in Washington. We can provide more rights to the residents of our states.
So, I want to come back to that one in terms of some of the federal rulings that we are hearing and seeing and how they do impact New Jersey, and what our Supreme Court and even our legislators have done to try and insulate against that in some ways, maybe somewhat with some effect and maybe a little less in other areas. But before I do, you mentioned before the 6-3 decision, right, on the state's legislatures and federal elections, which was, I think for everybody a little bit like, okay, you better go to the right way on that one. But there was some other decisions as well. There was a 5-4 decision in the voting maps in Alabama, which I think was a little more surprising, maybe. How do you interpret both of those kind of results in the context of what this court is and why they were put there? Are you surprised in any way that we got those rulings? Maybe the Alabama one a little more surprising. Are you surprised we got those rulings? And do you see a potential maybe for a justice, maybe Chief Justice Roberts or some others to kind of feel that the court is moving too far and maybe pull it back in some ways?
I think people who study courts recognize that courts' ability to get things done is inextricably tied to their legitimacy, the perception that they're acting in the public interest, that they're doing the job that they're supposed to do. And I think last term, because of Dobbs and a series of other decisions, the court's legitimacy was called into question, and it continues to be, notwithstanding the Chief Justice saying things about how all of the justices get together and we all like each other. There are real questions about what this court is doing, its respect for precedent and things like that. And I think at least Chief Justice Roberts and probably Justice Kavanaugh as well worried that the court had gone too far, and they weren't going to back off of their reactionary decision in Dobbs, but they didn't think they needed to go so far so fast. And in part, that's right, because they have this 6-3 supermajority. But the Allen v. Milligan case, the Alabama Voting Rights Act case, was a surprise given the hostility that Chief Justice Roberts has shown towards the Voting Rights Act. I mean, he himself wrote an opinion that did more to dismantle the case than the act than nearly anything else. But here he said, look, we're not opining on anything more than saying under a straight application of the Voting Rights Act, Alabama has violated it by creating only one majority black district, despite the fact that 2 could easily be made. I just read that Alabama has submitted a new map that seemingly will again violate the Voting Rights Act, really testing the court's mettle to see, well, did you mean what you said? And it will be up to the court to hold Alabama to it. But the stakes are high, right? I mean, there's no doubt that what is at stake is the rigging of future elections, trying to, through gerrymandering, through various forms of discrimination in the setting of districts, in redistricting, trying to strip certain Americans, particularly Americans of color, of the right to participate meaningfully in our democracy. And so it was a near miss and one that I wouldn't have predicted. But it doesn't make me breathe that much of a sigh of relief. What it says is we have this semi-rigged system. They tried to rig it a little too much, and that goes too far. I would rather a ruling that said, let's have fair elections that are truly one person, one vote. We're not there yet, but I do think had we lost in Allen v. Milligan, we would have seen far worse results.
Yeah, well, I think that when you start to not only the courts you're seeing, and I guess it's an argument chicken egg here, right? When you see the courts the way they operate, and you mentioned gerrymandered districts and disenfranchising, certain more significantly people of color from voting, and it seems like there's just a lot in terms of threats to our democracy, and I'm glad to see that you still remain hopeful in ways, and let's go back to that. You remain hopeful because of the ability of states to kind of take action and move forward. Certainly, I think we'll all note here, we're New Jersey, we're thankful for that, and we're a lot different than a lot of other states. So let's start and concede that point. But for us here in New Jersey, you mentioned the court, and you mentioned the courts and what we've done in terms of a lot of legal cases to kind of offer these protections. There are examples of legislation here in New Jersey that has come forward in light of U.S. Supreme Court rulings to try and protect New Jerseyans. I can think of right away. I think of the gun rights laws that have been passed, even conversation and laws around abortion. These are all things that New Jersey has kind of jumped into, even more so given the federal Supreme Court's rulings. But and I'll ask this then as my question. Even with, let's go to the concealed carry is a good example, right? Where New Jersey has tried to say, here's where here's where it's limited. There's been some pushback to say, well, you've gone a little too far, maybe not. We're going to reconsider. We see that working its way through the courts. From the decisions you've seen so far, how effective do you think that position will be for places like New Jersey, or New York, I'm sure, which was originally based on others, to take these actions at the state level that in some way insulate from the rulings of the federal Supreme Court? Yeah, so it really, you've got two different types of cases, and guns and abortion are on kind of opposite ends of that spectrum. So on the guns side, the position that the court takes is that the right to carry a gun, the right to own a gun, is an individual right. And so what they say when they strike something down under the Second Amendment, what that means is states can't provide less ability to own a gun than the court has set forth. So whether it's concealed carry, in the next term, they're going to consider whether a state can prohibit someone against whom a domestic violence restraining order has been issued from owning a gun. If the court says that the Second Amendment allows that, then neither the New Jersey courts nor the New Jersey legislature will be able to do much about it, because the court will essentially say that is unconstitutional if you do it. The abortion question is different, because what the court did in Dobbs was say there is no federal constitutional right to an abortion. That is a separate question from whether or not there is a state constitutional right, which our court has long since held there was, or whether there's a state statutory right for New Jerseyans to control their bodily autonomy and make decisions about their reproductive future. And so there are places where there are huge opportunities for the legislature and the legislature and the courts to step in, but guns might not be the place where they'll have a lot of success. They might, and there certainly are. They can keep trying to push the contours of the Second Amendment, but the kind of bizarre jurisprudence that the U.S. Supreme Court has adopted essentially says if it wasn't banned in the 1700s when the Second Amendment was passed, then it can't be banned today. Strikes me as a originalism on its head, but that is the idea. Mm-hmm. You mentioned a couple other cases, but what do you see as the ones coming in the future from the U.S. Supreme Court that are probably going to have the biggest impact, on us here in New Jersey and certainly nationwide? But what do you see as the next big cases that are, potential to really, overturn established law or just move us in a direction again where we're, stomping on individual rights and freedoms?
So there are three that I've kind of identified for the next term, but this court has a way of unpleasantly surprising us as the months pass with new cases that seek to do damage. But the three that I've kind of identified as certainly coming up next term that we are going to need to be concerned about are the first is the gun case that I mentioned, the question about people against whom domestic violence restraining orders have been issued. That will impact New Jerseyans for sure, one way or the other. It will be a decision of consequence. Probably the biggest case for next term that the fewest people understand, myself included, deals with a doctrine called Chevron deference. And this is also about the administrative state. And what Chevron deference is a court doctrine that's almost 40 years old, where what the court said is, look, when Congress is ambiguous in their delegation of authority about something, what can be done, how exactly does it work? And there's an administrative agency who has expertise about that area. If the agency makes a rule that's not inconsistent with what Congress said, then we defer to the agency because they have the expertise. So, for example, if Congress says, you should regulate air pollution, and then the EPA says, okay, the way we're going to regulate it is we're going to say it must be X number of parts per million or something like that. Well, that's the sort of thing that certainly the EPA knows more about than Congress, so we're going to defer to the EPA. And that's true whether we're talking about pollution or financial regulation. In the case that's coming up this year, it's about fishing regulations. There's a fishing regulation that says in order to prevent overfishing of certain bodies of water, you have to put something on your boat that tracks the number of fish you caught. I certainly am not a marine biologist by training. And we're going to make the fisheries pay for these tracking devices. Well, they sued, the fishing associations sued to say we shouldn't have to pay for it. And I don't think anyone is particularly worked up about who pays for these fishing trackers, but everyone is worked up about the idea of whether or not the agency that regulates fishing can fill in the blanks of the statute. The broad framework is set by statute, but they don't have to regulate, well, it must be this many fish or that many fish, because that's beyond Congress's expertise. That's what Chevron deference has done for 40 years. And the right-wing political establishment has put Chevron deference as kind of number one on their hit list, because if you get rid of Chevron deference, what you'll see is business interests suing to overturn regulation after regulation after regulation, whether you're talking about labor laws or environmental laws or financial regulation pieces. All of those things are subject to significant attack should that case come out the way that many court watchers are predicting.
Do you put one like that in a category, though, of is that one of the floor or the ceiling examples where in a New Jersey, use that example, let's say our bodies of water, could our New Jersey Supreme Court say, you know what, in New Jersey, we are going to do exactly that. And we are going to, are you still seeing a space for that even in cases like that?
Yes, both in the courts and in the legislature. So right, if the, this is going to be federal laws. And so if the federal government can't say you have to put these devices in your boats, the New Jersey legislature still can require that fisheries in New Jersey put those things in their boats, or that power plants in New Jersey pollute less. I think there are going to be some questions of federal preemption depending on the regulation, but there still are certainly opportunities for state legislation and for state judicial action.
We're hearing a little bit about that talk. Usually it's California, right, because of how big their economy is. But, are you seeing a sense where, you are going to see states band together to, maybe go in lockstep with one another? Much maybe people have been following at California when we think of emissions and other things. But is there a push around, if the federal government is going to be handicapped in that way for protecting some of these rights, that this coalition of states on a number of issues are going to be taking actions, maybe in unison to kind of get the protections that we need? Any sense of that?
I think that is certainly going to happen. I think there are limitations based on things that are part of interstate commerce and the ability of the Congress's exclusive authority over regulating interstate commerce. And so, for example, New Jersey isn't empowered to create regulations on fish, let's say, that are going to be fished in New York and eaten in California. That's going to be more of a federal question. But they're going to be really complex questions. But I will tell you that business interests are jumping for joy at the possibility of less regulation. And those of us who would like to, have crazy thoughts like breathing clean air or drinking clean water or not having a totally rigged economy are going to suffer.
Well, and I guess, should that happen, should they continue down this path? I guess the circular discussion here coming back to what do we do to change the courts? I guess that's the answer again, right? We're looking at what kind of modifications do we do in terms of people being added to the court or, some of the conversations around terms, et cetera. I mean, I guess that would really be we're back to that again, right? Or
let's have a legislature in Washington that can actually govern, right? Let's at some point, it may be true, it may be true that both political parties care about having clean water, that the 15 consecutive days of 100-degree heat in Miami causes even people who are anti-environmental regulation in Florida to say, wait, hold on, this isn't sustainable. And so there are ways that Congress can act. There are ways that the courts can act. I think court reform is an important conversation, but ultimately I also think we have political power, right? And so building political power is important in all of these fights. It's important because it makes court reform more likely. It's also important because it makes progressive legislation or life-saving legislation more possible.
Well, I have to smile because as we started this, you stated that you are someone who's not an expert on the courts and all the decisions happening, but you clearly have proven otherwise that you are very much an expert on the courts and including the U.S. Supreme Court and everything they're considering. So I can't thank you enough for a great conversation and really insightful and really just helping to educate me and I hope certainly our listeners as to what we're facing, some of the optimism that's there, and certainly things that we can push for and continue to hope to see in our state and in others, and some of the challenges we face as well. But certainly all of it exciting to hear about and certainly appreciate the conversation.
It's been a real pleasure. Have me back sometime to talk about good news. How about?
I'll take you up on that. I'd love to be having that conversation. So absolutely.
Sounds good. Take care.
Awesome. Thank you.